All right, want to go ahead and call this meeting to order. I want to welcome everyone to the House Judiciary Committee. Appreciate everyone being here this morning. We'll begin as we always do with a prayer, if you'd like to join me in prayer. Dear Heavenly Father, we thank you for this opportunity to work on behalf of the people of the state of Georgia. Please be with us today as we consider important legislation and public policy impacting the people of Georgia. And we ask for peace in Ukraine, for you to be with the people of Ukraine currently under attack. In Jesus' name I pray, amen. All right, so we have three bills that were on the original agenda that was published. Just for scheduling purposes, if anyone is here for Senator Strickland's grandparents' visitation bill, we are not going to hear that this morning. That's still undergoing review and revision by Chairman Strickland. We do have two other items on the agenda, and at this time I'll call SB 359. Chairman Albers is here with us, and Mr. Chairman, I'll let you introduce any witnesses that you want. You're welcome to have anyone sit with you if you'd like. All right, thank you, Chairman.
Thank you, Mr. Chairman and committee members. First, I want to thank you personally and your committee for helping us to continue to tweak and perfect this bill through the process. It's very important. I want to take a moment to acknowledge District Attorney Fulton County, Ms. Fawny Willis, who her and her team, which will come up, and I'll let them introduce themselves as well, have been instrumental. And just to give a very quick background, because I know that you're busy, we're all concerned about the increased crime and specifically the gang crisis that we're dealing with. 70 to 90% of the crimes that are violent in this state are being committed by gangs. It is something that we are all well aware of. However, we have to have the tools in place for all levels of the criminal justice system in order to prosecute these folks and make sure we put repeat violent offenders away. This is criminal justice reform. Make no mistake about it. And I think going to the spirit of what Governor Deal started, which I think most of us in this room are very proud to support, was we were going to separate those who we were mad at versus those we were afraid of. These are the folks we're afraid of, and we need to do something about it. We held a series of public safety meetings, as the House did as well, throughout last summer and fall. We met with prosecutors, DAs, judges, police chiefs, sheriffs, the GBI, Georgia State Patrol, Fraternal Order Police, bondsmen, police foundations, pardons, paroles, corrections, community supervision, victims' rights and activist groups, the governor's office, and just really got a really good comprehensive understanding and input from all these critical areas. And from that, as some of us are aware of, Mr. Chairman, you and I sit on the gang task force that the governor put into place, which I think has been an extraordinary step forward that Governor Kemp has done to bring all these groups together to really make sure we're communicating and working together as a team. So with this bill, which is the Safe and Secure Georgia Act, we're doing a variety of different things. And what I'd like to do is bring up some additional firepower here with District Attorney's Office. And I'll ask maybe Mr. Mike Carlson to come up first, and then we'll go through the bill quickly, and then I would love for you to hear from the DA, if that's okay.
Absolutely. Thank you. All right, Mr. Carlson, we'll hear from you. We are on kind of a tight timeline this morning. I have multiple witnesses lined up, so if you'll just do a quick run through of the bill.
Certainly, and there have been some slight changes, Mr. Chairman, since this was passed through the Senate. So the first section of the bill we're looking at, which would be Section 2, deals with principally increasing the penalty for possession of a firearm by a convicted felon where the felon is a prior domestic violence abuser or family violence abuser. So I'll go to the, and that increases the penalty, and also
It'll be a 5 to 10.
Move up to 5 to 10.
Yes, sir.
Then we have at Section 3, supplementing, as was done about 10 years ago with regard to another section or subsection, supplementing the purpose section of the Georgia Street Gang Terrorism and Prevention Act to detail that gangs function as criminal enterprises. Then we have at Section 4 the race judicata provision that is contained in the Street Gang Act. This is expanding that or clarifying that to ensure that the evidence of prior adjudications in adult court of criminal street gang activity can be used in subsequent civil action, and that would include civil gang injunctions. Then we have at Section 5, we have a Street Gang Act version of a multi-county venue provision. This parallels what currently appears in our racketeering statutes and would allow for, as far as Street Gang Act violations go, ensuring all of the evidence of the gang's activity could be put in front of juries. Also, this would be of assistance to the Attorney General's forthcoming gang prosecution unit. At Section...
Mr. Carlson, I'll jump in. Section 6 and 7 are riders. This is the COVID provision carried by Judge Gunner last year that allows for accusations for a period of time for certain offenses in order to move criminal cases through, and we're just extending the sunset on that to December of next year.
Certainly.
Thank you.
Thank you, Mr. Chairman. So now we're on to Section 8. This is recidivist punishment for subsequent convictions for acts of elder, disabled person, and that's the term in the statute, and minor abuse. Now we go to Section 9. This, as many states have done, revises OCGA 24-1-103 to encourage pretrial adjudication of evidentiary rules, assist in securing rulings, assist in getting those rulings, and of course, give courts guidance as to when and how to adjudicate pretrial evidentiary matters. Again, most of the adds in here came from what other states had added over the years, and that was certainly part of the inspiration. At Section 10 would be a new Georgia evidence code provision, 24-4-420. This provision is based on a California provision and several from other states. In the case of domestic violence, abuse, disabled adult abuse, child abuse of a non-sexual variety, and elder abuse, this would allow the jury to get a complete picture of the defendant's past commission of those sorts of abuses for any relevant purpose.
Similar evidence is admissible in cases involving allegations of sexual abuse. There are comparable evidence codes similar to this, right?
That's absolutely correct. The Federal Rules of Evidence adopted those, I believe, in 1994, and we pulled those in as part of our evidence code provision. In fact, in our evidence code, we have similar provisions for DUI and prior criminal street gang activity.
Thank you.
There may be just a proposed add to this just for some clarification purposes, Mr. Chairman.
Yes, sir.
And then to do the same thing with the interconnected Street Gang Act statute. And then as I go through there towards the end, our Section 11. This deals with allowing the GBI to assist law enforcement agencies in certain types of cases, and it makes sense for the GBI to be able to bring its expertise and experience and, of course, resources in for those purposes. Section 12 may need an adjustment or two, Mr. Chairman, just in terms of the effective dates due to some of the realignment. We haven't had a chance to look at all of that, but, obviously we'll take a look and make sure we report back.
All right, very good. So what I'll do now is give you an opportunity, Senator, if you'd like to call any other witnesses up that as part of your presentation.
Thank you, Mr. Chairman. I would be honored to bring up Fulton County District Attorney, Ms. Fonnie Willis.
All right. Good morning, Ms. Willis. Great to see you today.
Good morning. Thank you for having me this morning. I'm just here to really strongly encourage all of you all to look at this bill and understand that it is very much a bipartisan bill. I do not think that criminal justice has anything to do with what political party you are for. It just has to deal with the reality of we need this bill to assist us in our work to keep everyone safe. When I am working to keep people safe, they really don't care what party or what race or what gender you are. They are concerned about this. I like something that Senator Albert said very much. This is not about who you're angry with, who you're even annoyed with. This is who we are afraid of. and this is why this bill is needed. And so I want to talk about some really practical things and why it's important that we really look at this. I wrote a letter last night. I'm not going to go through all of it again, but I hit the things that were the most important. I know there's been some pushback. We don't want to go back several generations to where we're just giving these maximum penalties to everyone. But the recidivists that we're looking at in these cases are the people that are using guns. And it very, very much focuses on domestic violence. So I want to tell you something practical. Something practical is in Fulton County, which is 1 million people. I'm dealing with 70 domestic homicides right now. And the very vast majority of those have to deal with gun violence. And most of them are at the hands of someone who's already a felon. This is not who Republicans or Democrats are trying to protect. This is the worst of our community, and it's the hardest for law enforcement to protect because it's crimes that happen in your home, right? What are they supposed to do about that? We can't talk about more coverage of police in those areas because these are crimes that happen in their home. This is something that this bill goes to address, just the practical. Let's just talk about the practical of it. Also, I know that there's been pushback on this. What about having judges have to rule on orders? Well, I've been a criminal defense lawyer, and I know I have some other lawyers on the panel here as well, and I've been a prosecutor. Granted, of 26 years, 19 of it was as a prosecutor, but I certainly have some time as a criminal defense attorney. It is helpful to both defendants and prosecutors to know what evidence is coming in. We should not be having trials by ambush, right? If I am a defense attorney, I want to know what the prosecutor has and what the prosecutor doesn't have. And the only way you know that is if the judge has ruled on the motions. Then I can advise my client, hey, we need to go ahead and take this plea and resolve this case in a way that's in your best interest because the prosecutor has all this going in. Or to the alternative, I can say, the judge has ruled that evidence out. The police did something unlawfully. It's not coming in. And now I can advise you. As opposed to what happens now, you're in the middle of the trial and the judge makes a ruling at that point, and it's really trial by ambush. It's unfair to prosecutors and it's unfair to the defense. And we're in a time where Fulton County, and we're the worst because we're the biggest, we have 25,000 cases. I need to know which cases we should go ahead and resolve and which cases we should go ahead and go forward on. That's a real number. That's 25,000 or more victims, right? Because some cases have multiple victims. We need this tool to help us to resolve this. And so I just really want you all to look at this case. The other thing, that I hear people talking about, oh, you're just trying to penalize people. We're talking about penalize people that abuse the elderly, abuse children, or abuse people that are disabled, right? They're functioning as a child. This is who you took an oath to protect, and this is who I took an oath to protect, right? Children are not going to come and vote for you, but they certainly need your protection. People that are disabled, they're not really in our voting pool. This is the most vulnerable in our society, and this is who this bill protects. I will stand with Senator Albers on this. I'm completely behind him. This is a good bill that protects all people, and quite frankly, it's a needed tool, and it doesn't make you just pro-prosecution or pro-defense. It's something that is just fair, that helps everyone. And so I strongly encourage you to look at this bill and then ultimately do what's right and pass it. Thank you.
Thank you so much. Representative Bruce online has a question.
Yes.
If you or Senator Albers would be willing to take questions, sure. Ms. Wills. All right, Representative Bruce, if you'll unmute yourself and go ahead and ask your question, sir.
Okay, thank you, and good morning to everyone. I have a question. We have a whole lot of things mixed into this bill, dealing with gangs, dealing with all of the other things that Ms. Willis just referred to. And let me preface my question with, I totally support getting this crime issue under control. But the question that I have is, to what extent have we looked at other alternatives to seek out, why people are committing these crimes, and how do we address those things? And I'm talking primarily around the gangs. A lot of time these gangs are formed because people are looking for somewhere to belong to, something else other than what they're getting at home or what they're getting from other places. To what extent, if anything, have we looked at that in particular as other alternatives?
If I may speak to that, different district attorney's offices are obviously doing different things. But what I can tell you, Representative Bruce, is for one, the office in Fulton County, which is going to prosecute more people than anyone else in the state, we, for the first time in history, have a diversion program where we allow people to enter that program without even indicting them. That program assists with mental health issues. It assists with job training. In fact, this week I was really excited. I got to see some of my friends there where we have the Carpenters Union signing on to give people jobs while they're in our program. So when they finish our diversion, not only will we have their record erased, we'll make sure they have job skills. And quite frankly, I was thinking I made a wrong turn with going to law school, because a lot of them are on the track to make more money than a lot of us sitting in this room will make. We have looked into that as an alternative. I also went to the Superior Court bench in my county and dealt with the accountability of courts. We know that they would only allow people in the accountability courts, and so those are the courts that deal with mental health issues, that deal with drug issues. It used to be that before someone could get the benefit of that, you had to indict them. And I went to the Superior Court bench and said, does this really make sense? If we are trying to ultimately resolve them, why are we giving these people a scarlet letter? And so my office has also looked into that. So there are all different kinds of things. I 100% agree with you. We cannot only prosecute our way out of this problem. We have to have other alternatives. In the juvenile court specifically, I've hired on my staff, and we have partnered with the United States Attorney's Office to have what is a credible messenger. And so what is that? That is someone who has been involved in the criminal justice system, probably gone and done a stint in prison even, but they are reaching back to the children to show them this is not the way you want to go. And the reason we call them credible messengers is right because I'm the corny DA. So what youth is going to listen to me? I'm not cool at all, and I hate to tell the people in the room you're not cool either. But these people are people that have been involved in the system where the youth can actually respond to them. They can really listen to, you know what, it's no fun to be in prison. This is what goes on there. And so I agree with you, we have to have other components, but this goes against my worst of my worst. I am sick of gangs recruiting my children into them and making this the way of life. And our young people are the ones doing the most violent crimes. So you're right, we have to snatch them out through programming and do those different things. But those that choose this, you know, I tell people I'm a prosecutor's prosecutor. I don't mind putting them in prison for a long time because they don't mind hurting my community.
And let me just follow up with that. We're all concerned about our children, and this is cutting off the head of the snake in order to protect them in the future. Mr. Chairman, I'm going to go up and pass two very important House bills out of my Public Safety Committee, but after DA Willis speaks, we've got some victim advocacy groups that want to speak as well, and I'll be back down.
Always happy to excuse you to go past great House bills,
Very
Mr. Chairman,
important House
so
bills.
thank you. Yeah.
I'll see you in a minute.
Thank you. Well,
Thank you.
well, I hope that answers your question.
Yes, it
We-
does. Thank you very much.
We don't have any other questions. Thank you so much for being here today, Ms.
Thank you all
Willis.
for
Really
having me this
appreciate
morning.
your time.
I'm going to see the mayor of Atlanta now, so you will have to excuse me.
All right. Well, thank you so much for making time to be here to testify. We have a few other witnesses who are signed up. Mr. Jenkins, I'll call you next if you'd like to come forward.
Thank you. Good morning, Mr. Chairman.
Good morning.
Committee. First of all, thank you for giving me the opportunity to be here. I am also a member of the Fulton County District Attorney's Office, and I am the executive deputy of our trial division. And the types of crimes that I see are your beginning 7 deadly crimes, as in your kidnappings and your armed robberies, and specifically we deal with mostly our repeat offenders in our in terms of our firearms cases and in our drug trafficking and such. And so while my experts here behind me and colleagues, Mike Carlson and John Floyd, can speak to the matters in connection with the venue and gangs, I can tell you that the provision in this bill in connection with the pretrial rulings is something that I have dealt with, and I think it is appropriate, the language that we have in this matter in terms of the efficiency we have, in terms of our pushing cases on to their eventual resolution. And I can say this, that it would be helpful as a line prosecutor for many years here in Georgia and in Cleveland, Ohio, where I'm from originally. It is important to see and understand that we have certain rulings from the court that are beneficial to all parties. That means giving the defense an opportunity to fairly evaluate their case based on the circumstances, and as well as prosecutors. And quite frankly, I think it's a good thing. It may appear initially to be burdensome, but at the end of the day, once we get rolling, all parties being involved, it's a good thing, and we'll streamline our cases and move the 25,000 cases that we have backed up right now. And so it's just a good thing, and I really appreciate you guys giving me the opportunity to be here to speak on that, because obviously my division deals with our serious trafficking and narcotics cases that quite simply the state of Georgia and Atlanta and this metro area is a distribution center here for many organizations, our gangs, cartels, and such. And so many of the rulings that we have are important that affect our narcotics cases, and many times, and I can tell you that the bench is a very good one here and conscientious here in Fulton County, but there are just times in which possibly due to volume or whatever that they make rulings that are not timely sometimes, and in connection with the proper adjudication of our cases. And so I'm here to support the section in connection with 24-1-103 in this matter, and I hope that you all will vote accordingly to the support that we have shown to this bill at this time.
Thank you very much for being here. Oh, you just had a question. Representative Holcomb.
Thank you, Mr. Chairman. Thank you. I think that makes sense, and I appreciate that. I wanted to just ask quickly, because I think it ties to that, with the expansion of the jurisdiction under 16-5-12 on page 5. Is that an issue for you now, with having things suppressed or not being able to bring charges because of the county differences? And if so, can you comment on that? I'm supportive, but I'm just curious.
Sure. No, absolutely. It is. I mean, when you have matters that are of that nature in terms of the statute you cited, it's important because they're complicated many times. And with that, having an understanding in how to proceed and analyze your case from what the court's eventual ruling is going to be, it's important to have that information up front. And be quite frank with you, many times, and I hate to say anything, what I'm suggesting is that many times in the bench, I can't speak to any other jurisdictions, but in Fulton, sometimes the court has been comfortable in establishing certain case management orders that are not, I would just say, congruent with the actual discovery statute that we have here in the state of Georgia. And many of those scheduling orders are an impediment to our motion practice when it comes to making certain decisions because of these scheduling orders. And so I think that it's important that we have some form. Now, every courtroom doesn't do that, but there are a lot of our courtrooms that do have these scheduling orders, and that affects our ability when it comes to motions that need to be addressed or rulings that need to be heard, preventing us from filing those motions because of those orders. And what we're simply asking for is some form of uniformity in connection with the practice, and certainly the busiest jurisdiction and circuit in the state of Georgia.
So, Representative Holcomb, as to Section 5, I think important things to note is, first of all, this would only be for prosecution of criminal gang charges,
Exactly.
not for other charges, and it is similar to the RICO venue provisions.
Understood.
Okay.
Okay, thank you. And
Sorry.
just a quick follow-up on that in terms of the pretrial aspect, is my sense is that will help you with the allocation of resources, because if you have a ruling that maybe doesn't go in the favor of the prosecution, you can then make that decision in terms of whether or not to advance the case a lot sooner in the process.
Absolutely.
True or untrue?
That is true, and the efficiency is important because of the volume of cases that we have due to obviously COVID and just the circumstance of the last couple of years. And so it is just, while it may be new and for some may be uncomfortable, it's just necessary at this point in time for a prosecutor or a practicing criminal litigator here that's in the trenches daily.
Thank you.
All right, thank you. Thank you very much for being here,
Thank
Mr.
you.
Jenkins.
Thank you.
All right. Next up, we have Mr. Floyd. If you'll just come forward, introduce yourself, and tell us anything you'd like to share.
Good morning. I'm John Floyd. I'm a Special Assistant District Attorney of the Fulton County DA's office. I assist on RICO and gang cases. So my comments are limited to 16, 15, 12. This is not a controversial provision. Basically, gangs are a form of criminal conspiracy. It has been the law for longer than we need to count that a member of a conspiracy can be tried in any jurisdiction in which any member of the conspiracy has committed any overt act. We're simply modifying this and the RICO venue provision, which achieves essentially the same thing, to make it fit gangs. And one of the reasons for this is that, I'll just put it bluntly, I mean, for 25 years, I've worked with different district attorneys' offices and attorneys general here and in other states. The problem is not that we have too many gang cases, it's that we have too few. And it is that they are not as comprehensive as they should be. That is changing gradually. But it is important that when one of these cases comes out of the gate, it covers, the footprint matches the criminal activity of the enterprise that is engaged in it. So we today see a situation where members of a gang, and there's not any question about whether they're members. They wear it on their skin, they wear it on their clothes, they announce it to the world, they use social media to advertise it. They are all in for the rest of their lives. They are selling drugs in one county, they are committing a murder in the second county, they are intimidating a witness to that murder who lives in a third county, and they are attacking a witness or a rival gang member in a jail in a fourth county. This activity doesn't stop with arrests. It literally goes wherever the people are. And we need to be able to prosecute effectively in that way. Prosecutors should not be more territorial than the gang members themselves. They don't recognize these boundaries. As long as the activity is related to that gang and there is a clear nexus with it, it is crucial that that activity be brought comprehensively in one case. That's the model we're hoping to adopt, and it's a model that can help prosecutors across the state. The federal system deals with this smoothly. We can deal with this smoothly too.
All right, thank you very much for being here today.
Thank you.
Next up is Karima Dillard. Hi, good morning, Ms. Dillard. If you just introduce yourself, please correct me if I mispronounced your name, and we'll hear anything you'd like to share.
Pronounced it perfectly.
All right, wonderful.
Yeah. Good morning, Chairman of Stration and members of the committee. My name is Karima Dillard, and I am the Policy Director for the Georgia Coalition Against Domestic Violence. This is my first time testifying, so I'm happy to be here, albeit quite nervous.
Honored to have you here today.
Give me just a second to pull up my testimony. I have my trusty laptop here as I didn't have time to print it out. This will be short. The Georgia Coalition Against Domestic Violence is actually a member-based organization. We're often conflated with the Georgia Commission on Family Violence. It's our sister organization. But the Georgia Coalition Against Domestic Violence represents more than 60 domestic violence programs across the state. We're a technical assistance organization, and I'm here to lend our voice to the discussion on the Safe and Secure Georgia Act. I'd like to start out by saying that for years now, domestic violence advocates have been very vocal about our support of strengthening protections for domestic violence victims and survivors, particularly when it comes to firearms. One of the longtime priorities of the coalition, as well as the commission, has been to match the federal language of the Lautenberg Amendment, which prohibits anyone convicted of a domestic violence felony or misdemeanor from possessing a firearm. This language is important to us because research has shown that when there is the presence of a firearm during a domestic dispute, it increases the likelihood of fatality by 500%, and that's regardless of who owns the firearm. The Georgia Commission on Family Violence recently published data which finds that last year in Georgia, 83% of domestic violence fatalities involved a firearm. and family members and children comprise the second largest subset of bystanders killed during domestic violence related incidents. So there's no question that we want guns out of the hands of those who perpetrate harm. And though we understand that there may be unintended consequences of this bill where mandatory minimums are imposed for persons who may be erroneously convicted of family violence, and that's namely survivors who are sometimes incorrectly identified as perpetrators when in fact they're victims, we absolutely consider SB 359 a method of harm reduction and a first step in codifying language in our statute that would make it difficult for domestic violence abusers to legally possess a firearm. In a similar vein, we also appreciate language in the bill that would allow evidence of past abuse to be considered during a criminal or civil proceeding in which the person has been accused of family violence, and that the language of this bill matches some of the language in the dating violence TPO bill that was sponsored by Chairman Gaines last session, which includes a current pregnancy in common in the relationship definition of persons who could be considered a victim or perpetrator of domestic violence. I would be remiss if I didn't also say that we would prefer the language go all the way to include victims of dating violence as is defined in HB 231, which passed last session. All that said, we support SB 351, and I will do my best to answer any questions that you may have. Thank you so much for your time.
Thank you for being here. You don't have any questions. Appreciate
Great,
you being
thank
here. All right, we have Jill Travis next. Morning, Ms. Travis.
Good morning. I'll make it official. My name is Jill Travis. I'm the Executive Director of the Georgia Association of Criminal Defense Lawyers. I'm pleased to be with the Judiciary Committee this morning. We have concerns about three sections, well, a comment about one and concerns about two sections of the bill. Section 10 of the bill, which is found on page 10 and 11. This is plowing new ground for Georgia. You will remember very clearly that we adopted the federal rules of evidence. We have federal rules of evidence that mirror 413, 414, 415 in the federal code. And here Georgia is stepping out, what we would say, on a limb that doesn't need to be. The 404 provides adequate ways for the prosecution to get in evidence of other transactions or other similar crimes. There hasn't been, in neither the Senate hearings nor the House hearings, have we heard of any instances where the prosecution hasn't been able to get in evidence, so that this was necessary. Unlike some of the other testimony with regard to the need for changing venue and the very real problem that the prosecutors are facing right now, this is the phrase we use around here, a solution looking for a problem. But it's also very much hurtful to the defense, because it talks about the evidence shall be coming in. And we feel like 404 covers that adequately. We'd ask the committee to consider removing Section 10. The other, and I should have started with this. This bill is so much better than it was in the Senate. And we really do appreciate the hard work that the House committee has done in making the changes that are here. And so don't take my criticism as any kind of comment that I do not appreciate the improvements that have been made. You haven't heard my refrain as much as Chairman Burchett has about mandatory minimums, because this is the first time we've had it in your committee. We would ask you to consider changing the language in Section 8 of the bill, on page 7, starting at line 166, which is the very last line, provided that no portion of the minimum sentence prescribed for the offense shall be stayed, deferred, probated, or suspended. That same language is at line 178, provided that no portion of the minimum sentence. We have a lot of confidence that our judges will do the right thing, and we ask that the legislature not provide for the punishment in this manner. And lastly, just a note, of gratitude for including the extension of the sunset on accusations and bench trials. We have been working on that. I think that there are actually some other changes that we would like for accusations, but we understand time is of the essence at this moment, and we can only go so far. But I didn't want to not comment on that. I'm happy to answer any questions that you have.
You don't have any. Thank you so much for being here this morning. So, Mr. Carlson, what I'll do is ask you to come back forward. Mr. Carlson, so committee members know, knows quite a bit about the evidence code and was active in the passage of the adoption of the Federal Rules of Evidence and the Georgia Evidence Code. And what I'll do is just give you a chance to provide any proposed amendments that you think may be necessary today, and to succinctly respond like we would typically offer the bill sponsor to do, because Senator Albers is not here. We typically give the bill sponsor the last word, and you can fill that role for us here today before we vote.
Understood, and thank you very much, and I will endeavor to live up to that introduction, and of course, would not presume to sit in Senator Albers' seat, but will do what I can here. In terms of, let me go directly to the criticism of proposed Rule 420. Numerous jurisdictions, including Georgia, have taken these provisions that allow for easier admissibility and for broader purposes of certain types of uncharged misconduct of civil and criminal defendants. Again, this is based on a California provision that has been on the books for years and years and years and has been enhanced there. So federally and in Georgia, those have existed in connection with sexual offenses. Georgia expanded that in its original evidence code to include driving under the influence for a similar provision. And then, of course, Georgia expanded it again for prior acts of criminal gang activity. Other states besides California have statutes like this, similar to the domestic violence provision that's in here. That's usually where these come in. So the question on any evidence provision is A, whether the evidence is going to be admissible. This encourages that admissibility in cases where someone has committed prior acts of abuse of these particularly vulnerable people. And then how is always the second question with regard to evidence law. How will that evidence be considered once it is admitted? And this broadens that as well, because again, we are talking about abuse of the most vulnerable. The people who do that, just like with sex offenders, just like with gang members, tend to be repeat offenders, and the jury needs to be able to consider that for the broadest purposes possible. Quite frankly, as Senator Albers has said before, these kind of victims should not receive better justice in California than they do in Georgia. And that is what this seeks to repair in terms of our evidence code. We have numerous provisions in our evidence code that don't appear federally. As everyone here knows, or many here knows, I was probably one of the largest proponents of adopting the federal rules of evidence, but sometimes matters come up in any particular state that need attention. That's what this does here. There is a slight language adjustment that could be made here, and I'm going to, wherever the word commission of appears, we would recommend adding the words any other. So if I have this correctly, at line 231, and admittedly I was working on an earlier version on this before, of any other family violence or domestic abuse.
So it'd be commission of any other. Any other would be added after commission of.
Correct. And this would be to correspond to the language in the federal parallel statutes on sex offenses, and also to help recreate the California statute this is based on, so our courts can rely on that jurisprudence. We go down to section, I believe it is at line 241, any other child abuse or cruelty to children. We go now into section C at line 247, of any other such offense or offenses. And then at line 253, commission of, add any other of such offenses. So again,
Any other edits that you're proposing for the bill?
there is a similar with regard to the, and I don't know, with regard to the similar provision at 24-4-418, which is not in the bill. There could be a similar ad there, but given the exigencies here, we may not want to get into that today. Okay. In terms of the pretrial motion issue, again, let me say, from our Supreme Court to the federal courts, all the way down to other statutory frameworks within our code, pretrial resolution of evidentiary issues is encouraged. In fact, we added that to our Daubert Rule 702 civilly years and years ago. And actually, that's a more aggressive provision in terms of mandating rulings. That has now been expanded to criminal cases without any question at all that I'm aware of about removing that section that was engrafted into our rule on the basis of this somehow foists work where it shouldn't be, or somehow that's a deviation from the federal rule. Sometimes when things get on the ground in any given state, there's a need actually to add language that will encourage implementation of federal jurisprudential principles. That was certainly done, as I know Representative Gunner will remember, and Representative Fleming remembers, in adding the preamble to our evidence code to encourage the utilization of federal authority. That was resisted by some at the time, but fortunately, better heads prevailed.
All right, thank you very much, Mr. Carlson. All right, what is the will of the committee? There's a motion to pass and second. Any amendments? Representative Smith.
Thank you, Mr. Chairman. I would offer the amendment AM 490054. I'll give Brock a minute to send those out.
Is this the constable bill that we previously passed unanimously out of committee?
Yes, sir, Mr. Chairman.
All
This
right.
is the exact constable bill. There's the issue of finding someone that resides within some of our counties to actually fulfill this role, and it would help our courts be able to make sure that we still have our constables fully in effect.
All right, there's a motion and second on the amendment, the Smith amendment. Any discussion? Hearing none. All those in favor, any objection to adoption of the Smith amendment? All right, hearing none, it's adopted. All right, Chair will propose an amendment as outlined by Mr. Carlson. It would be adding any other after the words commission of on lines 231, 241, 247, and 253. Any objection to adoption of the chair's amendment? Hearing none, it's adopted. I would also ask the committee to authorize legislative counsel to make any adjustments needed to make sure the title numbering is correct and that that's all lined up, title and sections properly numbered. All right, any objection to the chair's second amendment or request for authorization to adjust those numbers? Very good. All right. Well, the bill's now before us. Any discussion? Hearing none. All those in favor signify by, and it's this committee substitute SB 359 LC 490991S. All those in favor signify by saying as amended. All those in favor signify by saying aye.
Aye.
Any opposed? All right, very good. It passes unanimously. Senator Albers, we're going to give you a Rules Committee form as you leave here today that you can take upstairs, and thank you for being with us. Thank you very much, Mr. Carlson.
Thank you again for your leadership and that of your committee today.
Hopefully those House bills passed out of your committee upstairs.
Unanimously.
Outstanding. I'm glad to hear that. I want to thank all of our witnesses who are here today. Thank you, Ms. Travis, and thank you, Mr. Floyd, Mr. Jenkins. Very good. We will now move on to Senate Bill 276. Chairman Clark, if you'd like to come forward and present your substitute.
Thank you, Mr. Chairman. Members of the committee, the substitute to Senate Bill 276 is working from LC 471843S. What we're doing is we're substituting this bill for House Bill 109 that has passed out of this committee 3 separate times, passed out of the House 3 separate times, and has been held up in the Senate. With that, I mean, I think we're all pretty familiar with House Bill 109. I'll yield for any questions. There are going to need to be some amendments to update some dates throughout the bill.
So, Mr. Chairman, as I understand it, this is the Child Victim Protection Act that passed the Georgia House of Representatives last year.
Unanimously, yes,
All right.
sir.
And the proposed amendments would be changing 2021 to 2022 in lines 10, 31, 60, 62, and 64. Is that correct?
That is correct.
All right, any questions for Chairman Clark? All right, seeing none, I will call the bill. Is there a motion with respect to Senate Bill, the committee substitute to Senate Bill 276? It's a motion and second. The chair has a proposed amendment, change 2021 to 2022 in lines 10, 31, 60, 62, and 64. Any objection to the chair's amendment? Hearing none, it's adopted. Okay. All right, any discussion? Hearing none, I'll call the question. All those in favor of Senate Bill 276, Committee Substitute LC 471843S as amended, signify by saying aye.
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 Any opposed? All right, very good. It passes unanimously under rules. All right, for planning purposes, we will meet again today at 1:30. The only bill is Senator Strickland's grandparent visitation bill. That will be at 1:30 in this